Presidential Decree Number 968, establishing a probation system appropriating funds therefore and for other purposes. Section 1, Title and Scope of the Decree. This decree shall be known as the Probation Law of 1976. It shall apply to all offenders except those entitled to the benefits under the provisions of Presidential Decree numbered 603 and similar laws. Section 2, Purpose. This decree shall be interpreted so as to promote the correction and rehabilitation of an offender by providing him with individualized treatment, provide an opportunity for the reformation of a penitent offender which might be less probable if he were to serve a prison sentence, and prevent the commission of offenses. Section 3, Meaning of Terms. As used in this decree, the following shall, unless the context otherwise requires, be construed thus. Probation is the disposition under which a defendant, after conviction and sentence, is released subject to conditions imposed by the court and to the supervision of a probation officer. Probationer means a person placed in probation. Probation officer means one who investigates for the court a referral for probation or supervises a probationer or both. Section 4, Grant of Probation. Subject to the provision of this decree, the court may, after it shall have convicted and sentenced a defendant and upon application at any time of said defendant, suspend the execution of said sentence and place the defendant on probation for such period and upon such terms and conditions as it may deem best. Probation may be granted whether the sentence imposes a term of imprisonment or a fine only. An application for probation shall be filed with the trial court, with notice to the appellate court if an appeal has been taken from the sentence of conviction. The filing of the application shall be deemed after a waiver of the right to appeal, or the automatic withdrawal of a pending appeal. An order granting or denying probation shall not be appealable. Section 5, Post-Sentence Investigation. No person shall be placed on probation except upon prior investigation by the probation officer and a determination by the court that the ends of justice and the best interests of the public as well as that of the defendant will be served thereby. Section 6, Form of Investigation Report. The investigation report to be submitted by the probation officer under Section 5 hereof shall be in the form prescribed by the probation administrator and approved by the Secretary of Justice. Section 7, Period for Submission of Investigation Report. The probation officer shall submit to the court the investigation report on a defendant not later than 60 days from receipt of the order of the said court to conduct the investigation. The court shall resolve the petition for probation not later than 5 days after receipt of said report. Pending submission of the investigation report and the resolution of the petition, the defendant may be allowed on temporary liberty under his bail filed in criminal case, provided that in case where no bail was filed or that the defendant is incapable of filing one, the court may allow the release of the defendant on recognize the custody of a responsible member of the community who shall guarantee his appearance whenever required by the court. Section 8. Criteria for placing an offender on probation. In determining whether an offender may be placed on probation, the court shall consider all information relative to the character, antecedents, environment, mental and physical condition of the offender, and available institutional and community resources. Probation shall be denied if the court finds that the offender is in need of correctional treatment that can be provided most effectively by his commitment to an institution, or there is undue risk that during the period of probation the offender will commit another crime, or probation will appreciate the seriousness of the offense committed. Section 9, Disqualified Offenders. The benefits of this decree shall not be extended to those sentenced to serve a maximum term of imprisonment of more than 6 years, convicted of any offense against the security of the state, who have previously been convicted by final judgment of an offense punished by imprisonment of not less than 1 month and 1 day, and or a fine of not less than 200 pesos, who have been once of probation under the provisions of this decree, and who are already serving sentence at the time the substantive provision of this decree become applicable pursuant to Section 33 thereof. Section 10. Conditions of probation. Every probation order issued by the court shall contain conditions requiring that the probationer shall present himself to the probation officer designated to undertake his supervision at such place as may be specified in the order within 72 hours from receipt of said order. Report to the probation officer at least once a month at such time and place as specified by said officer. Section 11. Effectivity of probation order. A probation order shall take effect upon its issuance, at which time to the court shall inform the offender of the consequences thereof, and explain that upon his failure to comply with any of the conditions prescribed in the said order, or his commission of another offense, he shall serve the penalty imposed for the offense under which he was placed on probation. Section 12. Modification of condition of probation. During the period of probation, the court may, upon application of either the probationer or the probation officer, revise or modify the conditions or period of probation. The court shall notify either the probationer or the probation officer of the filing such an application, so as to give both parties an opportunity to be heard thereon. The court shall inform in writing the probation officer and the probationer of any change in the period of conditions of probation. Section 13. Control and supervision of probationer. The probationer and his probation program shall be under the control of the court, who place him on probation subject to actual supervision and visitation by a probation officer. Section 14. Period of probation. A. The period of probation of a defendant sentenced to a term of imprisonment of not more than 1 year shall not exceed 2 years, and in all other cases said period shall not exceed 6 years. B. When the sentence imposes a fine only, and the offender is made to serve subsidiary imprisonment in case of insolvency, the period of probation shall not be less than, nor to be more than twice the total number of days of subsidiary imprisonment as computed at the rate established in Article 39 of the Revised Penal Code as amended. Section 15. Arrest of probationer. Subsequent disposition. At any time during probation, the court may issue a warrant for the arrest of a probationer for violation of any of the conditions of probation. The probationer, once arrested and detained, shall immediately be brought before the court for a hearing, which may be informal and summary, of the violation charge. The defendant may be admitted to bail pending such hearing. In such a case, the provisions regarding release on bail of persons charged with the crime shall be applicable to the probationers arrested under this provision. If the violation is established, the court may revoke or continue his probation and modify the conditions thereof. If revoked, the court shall order the probationer to serve the sentence originally imposed. An order revoking the grant of probation or modifying the terms and conditions thereof shall not appealable. Section 16. Termination of probation. After the period of probation and upon consideration of the report and recommendation of the probation officer, the court may order the final discharge of the probationer upon finding that he has fulfilled the terms and conditions of his probation, and thereupon the case is deemed terminated. The final discharge of the probationer shall operate to restore to him all civil rights lost or suspend as a result of his conviction, and to fully discharge his liability for any fine imposed as to the offense for which probation was granted. Section 17. Confidentiality of records. The investigation supervision history of a probationer obtained under this decree shall be privileged and shall not be disclosed directly or indirectly to anyone other than the probation administration or the court concerned, except that the court, in its discretion, may permit the probationer of his attorney to inspect the aforementioned documents or parts thereof whenever the best interest of the probationer makes such disclosure desirable or helpful, provided further that any government office or agency engaged in the correction or rehabilitation of offenders may, if necessary, obtain copies of said documents for its official use from the proper court or the administration. Section 18. The Probation Administration. There is hereby created under the Department of Justice an agency to be known as the Probation Administration, herein referred to as the Administration, which shall exercise general supervision over all probationers. The administration shall have such staff, operating units, and personnel as may be necessary for the proper execution of its functions. Section 19. Probation Administration. The administration shall be headed by the probation administrator, hereinafter referred to as the administrator, who shall be appointed by the President of the Philippines. He shall hold office during good behavior and shall not be removed except for cause. Section 20. Assistant Probation Administrator. There shall be an assistant probation administrator who shall assist the administrator perform such duties as may be assigned to him by the latter and as may be provided by law. In the absence of the administrator, he shall act as head of the administration. He shall be appointed by the President of the Philippines and shall receive an annual salary of at least 36,000 pesos. Section 21. Qualifications of the Administrator and Assistant Probation Administrator. To be eligible for appointment as Administrator or Assistant Probation Administrator, a person must be at least 35 years of age, holder of a master's degree of its equivalent in either criminology, social work, corrections, penology, psychology, sociology, public administration, law, police science, police administration, or related fields, should have at least 5 years of supervisory experience, or be a member of the Philippine Bar with at least 7 years of supervisory experience. Section 22. Regional Office. Regional Probation Officer. The administration shall have regional offices organized in accordance with the field service area patterns established under the Integrated Reorganization Plan. Such regional offices shall be headed by a regional probation officer who shall be appointed by President of the Philippines in accordance with the Integrated Reorganization Plan and upon the recommendation of the Secretary of Justice. The regional probation officer shall exercise supervision and control over all probation officer with his jurisdiction and such duties as may assign to him by the administrator. He shall have an annual salary of at least 24,000 pesos. He shall, whenever necessary, be assisted by an assistant regional probation officer who shall also be appointed by the President of the Philippines, upon recommendation of the Secretary of Justice, with an annual salary of at least 20,000 pesos. Section 23. Provincial and City Probation Officers. There shall be at least one probation officer in each province and city who shall be appointed by the Secretary of Justice upon recommendation of the administrator and in accordance with civil service law and rules. Section 24. Miscellaneous Powers of Provincial and City Probation Officers. Provincial or city probation officers shall have the authority within their territorial jurisdiction to administer oaths and acknowledgement and to take depositions in connection with their duties and functions under this decree. They shall also have, with respect to probationers under their care, the powers of police officers. Section 25. Qualification of Regional, Assistant Regional, Provincial, and City Probation Officers. No person shall be appointed regional or assistant regional or provincial or city probation officer unless he possesses at least a bachelor degree with a major in social work, sociology, psychology, criminology, penology, correction, police science, administration, or related fields, and has at least 3 years of experience in work requiring any of the above-mentioned disciplines, or is a member of the Philippine Bar with at least 3 years of supervisory experience. Section 26. Organization. Within 12 months from the approval of this decree, the Secretary of Justice shall organize the administrative structure of the administration and the other agencies created herein. During said period, he shall also determine the staffing patterns of the regional, provincial, and city probation offices, with the end in view of achieving maximum efficiency and economy in the operations of the probation system. Section 27. Field Assistants, Subordinate Personnel, Provincial or City Probation Officers shall be assisted by such field assistants and subordinate personnel as may be necessary to enable them to carry out their duties effectively. Section 28. Probation Aids. To assist the provincial or city probation officers in the supervision of probationers, the probation administrator may appoint citizens of good repute and probity to act as probation aides. Probation aides shall not receive any regular compensation for services except for reasonable travel allowance. They shall hold office for such period as may be determined by the probation administrator. Their qualification and maximum case loads shall be provided in the rules promulgated pursuant to this decree. Section 29. Violation of confidential nature of probation records. The penalty of imprisonment ranging from 6 months and 1 day to 6 years, and a fine ranging from 100 to 6,000 pesos shall be imposed upon any person who violates Section 17 hereof. Section 30. Appropriations. There is hereby authorized the appropriation of the sum of 6,500,000 pesos, or so much as may be necessary, out of any funds in the National Treasury not otherwise appropriated, to carry out the purposes of this decree. Thereafter, the amount of at least 10,500,000 pesos, or so much as may be necessary, shall be included in the annual appropriations of the national government. Section 31. Repealing Clause. All provisions of existing laws, orders, and regulations contrary to or inconsistent with this decree are hereby repealed or modified accordingly. Section 32. Separability of provisions. If any part, section, or provision of this decree shall be held invalid or unconstitutional, no other parts, sections, or provisions hereof shall be affected thereby. Section 33. Effectivity. This decree shall take effect upon its approval, provided, however, that the application of its substantive provisions concerning the grant of probation shall only take effect 12 months after the certification by the Secretary of Justice to the Chief Justice of the Supreme Court that the administrative structure of the probation administration and of the other agencies has been organized. Done in the city of Manila this 24th day of July in the year of our Lord 1976. Signed, Ferdinand E. Marcos.